Hello folks, welcome to the Edupedia world and I am Abhinay Gupta. Today we'll continue with the topic, the Banking Regulation Act 1949. I hope by this time you have memorized the date 1949, right? So, in our previous lectures we have already seen the definitions. We have seen section 7 about the prohibition of use of the word bank, banking and the banking company. And we have also seen section 9, which is which says that you will have to dispose the non-banking assets in 7 plus 5 years. Then we had seen section 10A about the board of directors, the constitution, right? The various areas in which the directors have to be specialized, right? We have seen section 12A about the election of a new director, section 17 and section 18, that is the reserve fund and the cash reserve ratio. Remember, in the reserve fund, you have been given a specific percentage, that is 20% of the profit before declaring dividend, right? And in the cash reserve ratio, you have such percentage as per the guidance of RBI, right? Then we have seen section 21, where we discussed the power of RBI to issue directions, right? And there was another section. Section 21 is the powers of RBI, right, to formulate policy for giving out advances, right? Then we had section 21A, where we saw that the court will not scrutinize the rate of interest charged by the bank. And then section 29, which discussed about the account and balance sheet, who would sign, when will it be prepared and stuff. Then we had seen section 30, which dealt with the audit of the banking company, right? Also the special audit required by the Reserve Bank of India, right? And the disclosures that the auditor have to make, we have already seen that in the previous lectures. Then we had covered section 31, which talked about submission of return to the RBI, followed by section 32, which talked about submission of return to the registrar, right? And then we had section 35, which dealt with inspection, which could be conducted by an inspector assigned by the RBI, whether suo moto, on its own will, or on recommendation of CG, right? We have seen the procedure of inspection already, and we had also seen what actions can CG take, right? Like it can prohibit the receiving of fresh deposits and direct to apply for winding up under section 38, right? Then what we had covered is section 35A. Section 35A talks about the power of RBI to give directions to the banking company, and section 35B talked about the amendment of provision, that no provision can be amended without prior approval of the Reserve Bank of India. Then we had section 36, where we had discussed the other powers of RBI, right? And section 36AA, removal of managerial person, 36AB, appointment of an additional director by the Reserve Bank of India, and that they will not be counted in the total number, right? And that can be one or more than one additional directors that the RBI can appoint. Then we had seen section 36E, where we talked about the acquisition of the undertaking of the banking company by the central government. So section 36AE is what we had covered immediately in the previous lecture, right? And today we'll talk about the compensation that the CG would be giving to those shareholders, right, of that banking company whose undertaking has been acquired by the central government, right? So we'll talk a brief about section 36AE so as to create a continuation, to create a flow, right? So what we had seen in section 36AE is that the RBI, when the RBI gives the report to the central government after the inspection, then central government would decide, right? It would scrutinize the report and then it would decide whether or not the act of the banking company has been detrimental to the interest of the public, the board, the depositor, or even to secure proper management, they have not acted appropriately, right? And that has been occurred for more than one time, right? So CG would decide to acquire the bank, right? And then it would give out the appointed date, and from that appointed date, all the assets and liabilities of the banking company would vest upon the central government, right? And before that, they would also be given an opportunity of being heard to show cause as to why the undertaking should not be acquired by CG. If they're able to prove it well, then CG would not commence with the acquisition of the undertaking. Otherwise, the undertaking would be acquired by the central government, right? Then we had seen that all the properties, which is the assets and the liabilities, are transferred in the name of the central government. And also that any suits and appeal that were pending right, would continue for or against the name of CG. So right, so in section 36 AE we have seen the procedure for acquisition of the undertaking by the central government, and now the shareholders of the banking company whose undertaking has been acquired by the central government, would be given a compensation, right, because they are losing their shares, right, they are losing their stake. So in return of their stake that the CG is taking over, they would be given a compensation for the same, right. So this compensation would be given to the shareholders by the central government, because central government is the body that is taking over the entity, the entire undertaking of the banking company, right. And then the compensation would be calculated on the basis of the 5th schedule, right, on that basis, because that is a baseline, right. So that is a standard that has been created. So all the compensations for such cases would be determined as per the provisions of the 5th schedule, right. And then the amount of compensation that is being given to that would be given to the shareholders as per schedule, the 5th schedule, would be then discussed or consulted with the Reserve Bank of India, and then they would settle down at an amount of compensation to each of the, for the value of each of the shares, right, and that compensation will be forwarded to all the shareholders, right. Now there are two cases. Once the shareholders are informed about the compensation that they're supposed to receive, the point is whether or not the shareholders are satisfied with the amount of compensation as decided by the 5th schedule, and also in consultation with the Reserve Bank of India, right. So there are two cases. One is they are satisfied, yes, so that everything goes well, and that is the amount of compensation that they would receive, right. But what if they do not agree with the amount of compensation given to them? So in that case, they would give a request to CG in writing, right. They would make an application that, okay, this is the amount of compensation that you're giving us, but we are not satisfied. We are worth more. We are losing a lot more than what we are getting in return, right. So you need to reconsider the compensation that you are giving to us, right. So once CG receives the application, then CG would refer the matter to the tribunal, right, because even the request would be to refer the matter to the tribunal that is constituted under section 36AH for this very purpose, right. And now the point is, will CG consider all the application, and will it consider the application without time barred? The answer is no. There has to be a time barred within which, if you want to object, you can raise your objection. Otherwise, if that time passes, we will consider it appropriate, right. We will consider the compensation given by CG as per schedule 5 in consultation with RBI to be appropriate for the shareholders, right. If there is no objection, we would consider that it is acceptable to the shareholders, right. So that time period would be decided by the CG, by the central government, and would be notified by the central government in the official gazette, right. So if the shareholders are able to make the application to raise the request before that specified date, that can be any date, right, and that is the discretion of CG, they would specify it as per the notification in official gazette. That can be 1 month, 2 months, 3 months, whatsoever, right. So it is no fixed date, it would be as per the notification. So the shareholders will have to focus on the notification, and before that date, if they want to make a query, if they want to make an amendment to the same, they would raise a request to the central government, right. And then CG would consider the request. First thing is, the first parameter that it will check is whether it is received within the time specified in the notification, and second point of consideration would be that it should be received from not less than 1/4 in number of the shareholders of the banking company, right, and that 1/4 shareholder should be holding minimum of 1/4 of the share value of the company, right. That means 25% by value as well as by number. Both conditions have to be satisfied, right. So if these many shareholders would raise a request before that appointed date, CG would consider the request and forward the matter to the tribunal for deciding the exact compensation as per section 36AH, right. The tribunal is constituted as per section 36AH, right. And now, what compensation is to be finalized, right? So if the shareholders are not able to raise the request within the specified date in the notification, then the compensation decided by CG as per Schedule 5, 5th schedule, and consultation with RBI would be final and would be binding on all the shareholders and the central government, right? But if they raise a request within the due time, within the due period, right, then CG would forward it to the tribunal, and whatever the tribunal decides would be final and binding on the shareholders as well as the central government. There is no further call on the compensation decided by the tribunal. The tribunal will give away an unbiased compensation to the shareholders, right, as per the entire calculation and what is actually the worth of the share that the shareholders are holding, right? So that is all about section 36 AG, right? Section 36 AE and AG are a section in flow in combination. So it's better if you start with section 36 AE and then read section 36 AG, right? Then we move on to the other section. We have done the basic provisions of this act, right? Section 36 AG would be the last section where you had to understand and know the provisions of the act. How does it work and what happens, right? Because these are some specific things that are not given in any other law or in the Companies Act, right? And whatever is given in Banking Regulation Act would be applicable notwithstanding anything contained anywhere else, right? So the next section that we would be covering is to have an overall idea about the act, which is section 4, right, which says that CG's power to suspend the operation of obviously the banking company, right? So when does it do so? First is when the RBI makes a representation to the central government, right, with regards to any particular banking company or to some banking company in general, right? So that representation would be considered by the central government. CG would consider the representation made by RBI, and if it is satisfied that okay, the representation is valid and the operation is detrimental to the interest of the public or the depositor, banking company, or they are not securing proper management or any certain things, like if there is a situation where the operation has to be suspended to secure the interest of the various people, various entities, right? So in that case, CG would give out an order to suspend the operation of a banking company, right? And this will be given by a notification in the official gazette. And this suspension cannot exceed a period of 60 days. So as per the notification, CG may suspend it for 10 days, 15 days, 20, 30, 40, 50, 60. But at one point of time, it cannot exceed the suspension for more than 60 days. If it wants to suspend the operation for more than 60 days, it will have to give another notification for another period of 60 days or less as per the situation, right? And this notification can be given out for any banking company in specific or in general to all the banking companies if there comes a situation when the banking has to be suspended, right? And even the extension will have to be notified in the official gazette, right? So that is all about section 4. We move on to the next section, which is section 5A, which says that the act would have an overriding effect. This is the entirety of the act that we have been discussing throughout the lectures, right? That the act, the Banking Regulation Act, would always have an overriding effect on the memorandum, on the article, on the agreement that is entered by the company with anybody else or amongst the members, whatever. Any kind of agreement would never override the act, right? The act will supersede, right? And then any resolution passed either by the shareholders or the directors in the board meeting, whatever kind of resolution, either it is of ordinary resolution, special resolution, board resolution, no resolution would ever override the Banking Regulation Act. So when we talk about the resolution, no resolution would ever override the act, whether the same be registered, executed or passed, whatever, right, before or after the commencement of the Banking Companies Amendment Act 1959. Right? So ultimately what the conclusion is that no resolution will ever supersede the Banking Regulation Act, right? And if there is any provision which is inconsistent with the Banking Regulation Act, like if there is a provision related to any particular thing in your Banking Regulation Act as well as in any other act or law for the time being in force, that provision in the other act or other law would stand nullified, would stand void, right? It's not about only the act. If there is any provision contained in the memorandum, article, agreement or resolution, wherever, right? So to the extent it is not in agreement with the provision of this act, it would be void, right? And as I have always said in the lectures in the past, and what we need to actually keep in mind is the provision of section 2, which says that the provision of this act shall be in addition to and not save as hereinafter expressly provided in derogation to the Companies Act or any other law for the time being in force, right? So that is all about the provisions of the Banking Regulation Act. We have so far covered all the sections of the chapter that is important for you and that is given in your study material and other sources, right? And it has been covered in detail. So whatever questions you will be asked in your examinations, 99% of those questions would fall within the provisions that we have discussed in all the lectures combined. So on an average, if you consider this, you complete the entire chapter in 2 to 2.5 hours, right? So it is a very simple thing to do. So with this, I will be ending the lecture today. We have covered all the provision. In our next lecture, we would cover the important questions and the important topics that have been asked in your previous examinations and that remains important for your upcoming examinations too, right? So until then, stay tuned. This is Abhinay Gupta signing off. Thank you.